If you have a discrimination complaint and you're in the majority, does that mean that you have a higher burden to meet than someone in a minority? Well, the Supreme Court says no. A recent Supreme Court case in June stated that a person who's in the majority doesn't have a higher test to meet than somebody in a minority. What's a majority? Well, maybe it's a person who's white, male, straight, of a Christian religion. Basically, whatever particular class is a majority in the United States as opposed to the minority. The story here is that a woman in Michigan made a complaint of discrimination because she felt that she did not get a promotion because she was straight. And as a result, she filed a lawsuit, and the Sixth Circuit stated that she had a higher burden to meet to show discrimination because she was in the majority. And the Supreme Court struck that decision down, basically stating that the framework that we've always used, this McDonnell-Douglas test, has to be followed by everyone, no matter their religion, creed, protected class. Everyone uses the same burden test. So this will be an interesting case moving forward in terms of people bringing what sometimes we call reverse discrimination cases. What was particularly interesting is that a lot of the justices in their opinions discussed whether this McDonnell-Douglas framework that we've all been using for years is antiquated, is old, and whether we should do something new, and more or less encouraged claimants to bring this sort of question to the Supreme Court to be decided. So stay tuned. That would change a lot in the employment law world and maybe down the pike. If you have any questions, call Cramer Law.